In the Americans with Disabilities Act of 1990, Congress described the isolation and segregation of individuals with disabilities as a serious and pervasive form of discrimination. Title II of the ADA, which prescribes discrimination in the provision of public services, specifies that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of a public entity's services, programs, or activities. Congress instructed the Attorney General to issue regulations implementing Title II's discrimination prescription. One such regulation, known as the Integration Regulation, requires a public entity to administer programs in the most integrated setting appropriate to the needs of qualified individuals with disabilities. A further prescription, here called the Reasonable Modifications Regulation, requires public entities to make reasonable modifications to avoid discrimination on the basis of disability, but does not require measures that would fundamentally alter the nature of the entity's programs. Justice Ginsburg delivered the opinion of the Court with respect to Parts 1, 2, and 3, concluding that under Title II of the ADA, states are required to place persons with mental disabilities in community settings rather than in institutions, when the state's treatment professionals have determined that community placement is appropriate. The transfer from institutional care to a less restrictive setting is not opposed by the affected individual, and the placement can be reasonably accommodated, taking into account the resources available to the state and the needs of the others with mental disabilities. And so on June 22, 1999, in Washington, D.C., the Supreme Court affirmed the rights of individuals with disabilities to live in community settings.